Hi, everyone. Welcome. Thank you so much for joining us tonight. I'm so happy to be here along with our guest, Anne Roboloff, and my co-facilitator, Hadil Amari. And Hadil and I facilitate the Autism Support Group. And when we can, we're really lucky to get wonderful speakers like Anne that really help our group by sharing their wisdom with us. And so we really appreciate you being here with us tonight, Anne. And I just wanted to give a quick bio so everyone can get to know a little bit about Anne before we start. So Anne Marshall Roboloff has been working in the fields of estate planning, conservatorship, and elder law since the mid-90s. Anne earned her BS in political science and psychology from Santa Clara University and her JD and Master of Social Work from Tulane University. Anne is a frequent speaker at Bay Area events and recently coordinated with a number of local financial planners to provide education on ways they can aid their clients to avoid court involvement and plan for transitions within families. Working with her clients, Anne plans for their immediate and long-term security. With an educational approach, she uses her legal and cooperative family skills to facilitate informed decision-making. She supports families with estate planning, incapacity, special needs, and elder care, and is an active member of the State Bar of California and the Silicon Valley Bar Association. She supports Hope Services and the Alzheimer's Association. Anne and her family live in SoCal, where they enjoy hiking and gardening. Thank you so much for joining us tonight and presenting for us, Anne.
You are very welcome. I'm looking forward to it. All right, we are going to be talking about special needs trusts to begin with. So special needs trusts are a wonderful tool for families that have members that may qualify for benefits, certainly upon the attainment of the age of 18. So if there's a chance that children will be qualifying for benefits after 18, it's something that we're usually thinking about and talking about from an estate planning perspective, and certainly worth learning about as a parent. There's a couple of different types of special needs trusts. But in any scenario, any type of special needs trust is going to allow distributions to a special needs child without disqualification from government benefits. So it's not just the distribution, it's the management of the assets actually. So benefits programs can work in a number of ways. Generally speaking, they're benefits that we're looking to preserve by utilizing special needs trusts. So when you're qualifying for benefits, generally speaking, you're looking to have income and assets on hand of no more than $2,000. So when we're looking at inheritance planning for many families, and even in some cases, lifetime gifting, even birthday gifts can add up over time, we want to look at how we're going to do that for a special needs child. It's something that we can start thinking about early on so that by the time they reach the age of 18, they don't already have, I have a lot of families that come to me and the child has actually already saved up a significant amount of money through, it can be something so simple as an accumulation of birthday presents and holiday presents and those sorts of things. So, but certainly when we talk about inheritance planning, then the numbers can become much larger, and benefits qualification can be something that we really need to plan for. And this provides a vehicle to place assets and manage assets on behalf of somebody who may or may not. In some cases, they may be able to manage them on their own if it's not an intellectual disability. But under the special needs trust rules, they will not be managing them on their own. They will be managed by a trustee. So there's the benefit of the asset management. The assets themselves do not trigger disqualification, and distribution with careful planning, the distributions also will not trigger disqualification. So special needs trusts can be created immediately, or can be something that comes into existence following the death of a parent or at the death of a second parent if it's a two-parent estate plan. Do we have any questions or?
Yeah, and we have a couple of questions. Can the mild autism be converter of the severe autism?
Can the I'm sorry, can you give me the question one more time?
Okay, I'm going to move to the next question. Why do I need a separate special needs trust? And is it okay to include a special needs provision in an ordinary trust?
Yeah, so you can include special needs provisions in a revocable living trust that would be considered to be like an ordinary trust that many people, anyone who has more than $150,000 or who owns real estate in the state of California is likely, if they consult an estate planning attorney, to be told that it is a very good idea for them to put in place a revocable living trust for probate avoidance purposes. You can embed a special needs trust inside the revocable living trust, and that's the type of trust that would not be in effect immediately. It would be in effect only upon the death of the parent, or if it's a husband and wife or a couple that is creating the trust, both parents are creating the trust, or a parent and step parent, for example, they can have it structured so that there's no funding, there's no creation of the special needs trust, there's no funding, which would mean movement of money into that special needs trust until the trigger date, which would be the death of the parent or the death of the second person, the parent or the step parent. And then at that point, assets would move into the special needs trust, and it doesn't actually become a legal entity until that trigger date. There are reasons why some people would like to create a trust immediately, meaning that they create a standalone special needs trust. Upon its creation, it is funded with assets. It has a tax identification number, a bank account is opened, assets are actually held by the trustee upon the creation of the trust. So for things like gifts on birthdays, lifetime transfers for tax planning purposes, anything that it would, in some cases, it would be needed for a child that may be the recipient of a settlement from a lawsuit. There's a lot of special needs trusts that are created when there's a judgment awarding money to a disabled individual. So those are the types of cases where you really do need it to be set up and to exist as a separate legal entity and to be able to receive assets right away. And in a lot of other cases, we're talking about proactive planning for what happens for the inheritance after the death of the parent or parents. And in that case, we would be considering the approach of embedding it in a regular revocable living trust. So the special need language actually appears inside of the revocable living trust document, and it doesn't become a separate legal entity until that trigger date, whatever the trust calls for that trigger date to be, which would generally be the death of one or both parents. Are there other questions? You're on mute.
When is the right time to set the special needed trust? And can you start with an ordinary trust and then move to a special need trust when the child is older?
So was the first question, when is the right time to create a trust? Okay,
Yes.
so the time to create a trust is before incapacity of the person who will be placing the money in the trust. So for many of the individuals that I am drafting special trusts to benefit, their disability, there was never a period where they were over the age of 18 and not disabled. So there was no point where they legally had the ability to create estate planning documents. So these types of trusts are something that will be created on their behalf through the court system, or will be created by a parent or by someone else who is leaving money for the benefit of this individual. When any client considers when is the right time, so I think the bigger question is, when is the right time for estate planning? I think that light estate planning should begin as soon as we turn 18. Basic estate planning includes things like creating a power of attorney, creating a health directive for ourselves. As soon as we acquire assets of any sort, a will is a good idea. As soon as we have assets over $150,000 and we're a resident of the state of California, or as soon as we become a homeowner of any value in the state of California, it is now a good idea to have a revocable trust put in place. So these trigger dates, these trigger this timeline is actually much earlier than almost any client seeks out estate planning advice or puts estate planning documents in place. So generally speaking, by the time we think about it, we should be doing it. And that's a short answer. If you know you have a child very likely to receive assistance based on disability upon attaining the age of 18, my advice is you should put a special needs trust in as a component of your trust when you create a revocable living trust. I don't think it makes sense to wait and see how things go. I think that trusts should be looked at. I look at all of my clients' trusts every year. I do that for free because so much changes, and it's important that people receive advice about what they have in place and whether it's still meeting all of their needs. And some people don't want to do anything if they're told that it's not meeting all of their needs, but at least they know, at least they have that information. So there's always going to be changes in the law. These documents aren't stagnant. They don't just stay in working order if they're neglected over many years. So if you put special needs provisions in, and we all hope and work towards children as they are 5 and 10 and 15, we're promoting and working to engage them with services and to have them acquire skills and hopefully not meet the standards to need public assistance benefits, where we hope that we are actually working with children to be able to hit the age of 18 and go off to college and get a job and all of these things. So there's nothing wrong about putting a special needs trust in protectively. And then when you're going about all of the other updates to your estate planning documents that you really should be looking at and talking with your estate planning attorney about periodically, giving them the great news that, hey, you know what? We don't need that anymore. We can just do regular distribution provisions for all of our children. That's great news, welcome news, not something unfortunate or negative in any way. A skilled estate planning attorney that does special needs trusts with regularity, it's not hard for us to include a special needs trust in a regular revocable living trust. It's something that we have the language, we know what we're putting in when we put this type of trust in. It shouldn't be something that creates a huge burden on your estate planning. And if it does, it may mean that you're not working with a skilled estate planner. So I think you should include it. I think you should be proactively doing estate planning. It's something that saves people an incredible amount of money versus delaying in creating an estate plan. Because what happens is if you wait too long, there's a health incident that happens, there's the inability to put documents in place, there's a death that occurs, and now you have probate fees. So the probate fees exceed estate planning fees so rapidly that you cross that threshold to $150,000 and you're at a $200,000 estate, you're already paying more than you would have paid to do a really fancy estate plan in probate fees. So the idea of waiting a long time to do estate planning is not a good idea. And the idea of holding off to put a special needs trust in place, I also don't think that's a good idea as well. There was a hand up I see. So do we want to see?
All right. So the next question is a special needs trust and conservatorship always done together? Do they have to be done together?
They absolutely do not need to be done together. We are going to talk about conservatorship, but it is going to be in the second half of the presentation. They are really truly two different topics. So not everyone who would benefit from a special needs trust needs or wants a conservatorship, or the family members or the loved ones of this person may not benefit from conservatorship, and vice versa. Not every candidate for a conservatorship, that a conservatorship is a good idea to put in place for someone. Not everyone that falls under that category. For example, there are plenty of people who just simply don't have an intellectual disability or money, so they may not need conservatorship. But well, I guess in that case, they wouldn't need a conservatorship, but someone else might leave money for their benefit, in which case they would need special needs trust. So there are cases where you need one or the other. There's lots of cases where you need both. So your standard situation where you have parents come into an estate attorney and about having 3 children, one of whom has a significant disability. Often at the age of 18, parents will want to apply to the courts for conservatorships to make medical and education decisions for that child, and will also be doing an estate plan that includes special needs trust planning as well. So they do go together, but they certainly don't always go together.
And we'll take one more question and move on. So does the child have to have certain types of disabilities to have a special needs trust?
No, there's a lot of flexibility with special needs trusts. So it's a very general vehicle that can be used for many different purposes. For instance, you can use them for people who have drug addiction. You can use them for lots of different types of disability. And so certainly in the context that we're discussing them tonight, where we may not be actually talking about all the different uses that can be that can be met, or all the needs that can be met by a special needs trust, but it's actually a very broad group of beneficiaries that can be served effectively by a special needs trust.
Okay. All right. We'll move on. We'll take more questions after the next slide.
Okay. So when a client may be considering putting a special needs trust in place, there are a couple of different things that need to be considered. So there are first-party special needs trusts, there are third-party special needs trusts, and there are pooled trusts. Pooled trusts are administered by a nonprofit and generally would entail the turning over of money to that nonprofit and setting up a mechanism of requesting to receive the benefit from the nonprofit. So pooled trusts, I would say, are something that we don't need to spend a lot of time on. They are a good device for families looking to plan for an individual who there's some money earmarked for this person, but it's not a huge amount of money. And so the administration, so as a separate legal entity, a special needs trust will need administration, it will need management. And in the course of that management, it will need to file a tax return every year. The tax return will need to, it's a good idea to engage a CPA. So you're very likely to have CPA fees every year. There's a trustee may need to be paid. Many special needs trustees do not need to be paid, but payment of the special needs trustee can be something that will slowly erode the trust principal over time if it's a small amount of the CPA. So you don't want your professional fees to exceed the benefit to the beneficiary. So if you're in a case where the amount of money is not so great that you may find yourself in a situation where the administrative costs year over year are going to start to erode the principal itself. And so the benefit to the beneficiary may be slowly kind of diverted to professional service fees, then we would consider in those cases a pooled trust option. But for most families, they're considering either a first party or a third party special needs trust. And so when you come to these types of decisions, generally speaking, what you're looking at is where is the money coming from? So if you are talking about money that was received as a result of a settlement, so it's being received by the disabled individual, so it's their money, they're the one entitled to it, that would need to go into a first party special needs trust. If there's the child where the family comes to me and they've already gifted to their child, no one had gave them this advice, they didn't understand how our system treats people with disabilities that reach the age of 18, having received these gifted assets, or they started a savings account and the parents transferred money into it, not realizing the impact. Whatever the situation is, there where a child turns 18 and has built up some. That is that point. Option there is to put it into a first party special needs trust. The reason that we look at it as a kind of a discrete class of assets that need to move into a special needs trust and try to find ways to keep those things from happening is that a first party special needs trust is going to be required to go through Medi-Cal repayment. So once the assets are funded into the first party special needs trust, the individual can apply for Medi-Cal. And once they start receiving the benefits from Medi-Cal upon their death, Medi-Cal can seek repayment only for the cash out of pocket that was expended during the beneficiary's lifetime. But that money will not pass to alternate beneficiaries. It won't pass to siblings or grandchildren or whoever else might be the recipient in a traditional estate plan. A third-party special needs trust, on the other hand, would be what we would put in place for the parents leaving money. So to say, when I, the parent, pass away, I want my special needs child to receive my house or a brokerage account or a 1/3 share of everything that I own because I have 3 children and I want them all to receive the same amount. But the child that may or is already receiving benefits, I want to keep them qualified for those benefits. I don't want to disqualify from benefits at the time of inheritance. So by putting a third-party special needs trust in place, in those types of cases, we have a lot of flexibility, which is great. So there's a lot more planning options with a third-party special needs trust than a first-party. The rules are very strict with a first-party special needs trust. And some of the things that you can do in a third-party special needs trust that are really nice is to say, after the initial beneficiary, the intended beneficiary, if the assets, in some cases, the assets will be used completely during that person's lifetime, which is a great outcome because then the trust served its purpose and the beneficiary received all the benefit of all the assets in the trust. But we certainly do, on the other hand, try to budget so that we try to keep assets on hand so that as someone ages, there are assets remaining. So the idea is you want to give the benefit. You don't want to be too withholding and not have someone benefit from their special needs trust. But it is nice when you are able to stretch those funds through to the beneficiary's passing. So following their death, something with a third-party special needs trust that's very nice is that you would get to identify who the alternate recipients are. So it stays often within the family if it's a family estate plan. So it can go to the other siblings. It can go to children if the special needs beneficiary has their own children. The way a traditional estate plan would operate, it can operate just like that. So the third-party special needs trusts are very nice that way. They don't have to go through that Medi-Cal repayment stage, which in my experience, many of the first-party special needs trusts are significantly or completely depleted at the point of Medi-Cal repayment. Are there questions at this point?
Yes, we have some questions. So,
okay.
So let's start with, so what happens to the money in the special need trust at the death of the client? Does the government take the money or will it go to a family member?
So that's the distinction between first party and third party.
Yes, you just answered that, yes.
Yeah, so the first party special needs trust goes through a stage of Medi-Cal repayment. And so Medi-Cal essentially sends an invoice to the trustee. They send a bill for all the services. It's kind of interesting to see an itemized list of all the expenses that were paid. And they actually report line by line what they paid for. It's shocking how little they pay, which I know anyone using the Medi-Cal system is aware of the problems within the system because it's a benefit, but it's a benefit that puts the medical providers in a difficult position because they are not receiving anywhere near market compensation for the services they provide under that program. So it is interesting to review these invoices because it's a lifetime, sometimes, a lifetime history on someone's medical care they've received and what Medi-Cal paid out, what actually came from Medi-Cal to those providers. And so it's the total amount. It's not what fair market value for those services would be. It's the amount that Medi-Cal actually reimbursed to each individual provider. So in some cases, if you have $1 million in a special needs trust a lifetime of care, multiple hospitalizations, surgeries, you may not actually have the entire balance. It may not all be lost in repayment to Medi-Cal, but in a first party special needs trust, it's not until you go through that stage of repayment to Medi-Cal that you are able to distribute to the other beneficiaries, whoever they may be. The third party special needs trust doesn't have to pay any creditors. So it bears no liability to any creditor, essentially, unless the trustee of the special needs trust, the third party special needs trust, actually sign contracts on behalf of the trust. It would be liable to those creditors of the trust specifically because the trust engaged services. Once those contracts are paid, that trust, whatever the balance of it is at the beneficiary's death, goes to the alternate beneficiaries, and those alternate beneficiaries can be really drafted any way that the client wants them to be drafted.
Okay. All right. So how much does it cost to establish the special needs trust?
It will vary greatly between attorneys. So some firms are just in general more expensive than others. So there's going to be a huge, there's going to be a difference in cost based on what attorney you're working with. So probably between $2,000 and $5,000. A trust is going to be a trust on its own. I would say it's probably going to cost around $2,000. A comprehensive estate plan is going to cost for a single person between $3,000 and $5,000. For a married couple, $4,000 to $6,000. And in some cases, you're certainly going to find attorneys to do it for less than that. In other cases, you're going to find attorneys charging a great deal more. If the estate's very complex, that's going to drive the cost up just because there may be additional considerations that need to be kind of mapped into the plan. But the trust as a separate item itself, so if you did just a standalone special needs trust, only that will probably be around $2,000. If you do it as a component of the overall estate plan, it really shouldn't change the cost of the overall plan very much. And it's actually something that can be a great benefit to the whole family, really, without changing the cost of the estate plan very much. I think there was a question built into the first question about how the management of the assets works. Is that right?
I'm sorry, can you say that again?
Was there a question about the management of the assets?
No, I didn't see any, but I have more questions though,
Okay.
but not, yeah.
Okay.
So can a special needs trust exist as its own entity and not part of another living trust?
Yes, it will always, once it receives assets, it will always be its own legal entity. So the different trusts that we've been talking about are, the question with each is just at what point does it become a separate entity? But at whatever point that is, whether it's the death of the parent or immediately upon creation, it will get its own tax ID number and be a separate legal entity from any other component of anyone's estate plan.
Okay. Okay. So if you have a neurotypical sibling as well as a special needs child, can you create a trust for both of them together?
I have seen, and was the question if there are two different types of disabilities?
No, it's a neurotypical and a special need.
Oh, okay. So one revocable trust can be created to benefit both of them, but at the time of inheritance, they will become separate from one another. So at the time that the special needs trust will receive assets, it becomes a separate entity.
Okay. Okay, so we have more questions, but let's move on and we'll take more in a little bit.
Okay. Okay, so the assets now at this point, we're saying we've created the special needs trust. We've decided what type we're going to create. It's been created, and now we've actually placed assets into it. So the trust now has assets. Medical expenses that are not covered by Medi-Cal. So in some cases, a special needs trust will be in place and the person will not have successfully applied for and received Medi-Cal, so there may not be Medi-Cal benefits in the great majority of cases, there are Medi-Cal benefits. And so remaining qualified for Medi-Cal is a big component of what we do when we're doing the administration of a special needs trust. So the Medi-Cal program doesn't want people to be paying for the same services that Medi-Cal provides from the special needs trust. So cosmetic, dental work, extra procedures, there's a lot of things that are not covered under the Medi-Cal program. So those types of expenditures are a common use. Alternative therapies, I'm throwing out a couple of animal or art therapy, but there's just a lot of different types of therapies that are out there and that may be good, appropriate expenditures from a special needs trust. Recreational activities. Depending on how physically active a beneficiary may be, TVs, access to, I suppose now it would be all streaming services. It used to be DVD collections or a long time ago, VHS collections. So, things that are recreational, and that can be as broad of a category as there are individual beneficiaries. So for everybody, there's going to be something different that would be appropriate there. Travel. There are services that provide travel for individuals with disabilities that actually provide staff and all levels of assistance to be able to go on different types of trips. But a lot of my special needs trust beneficiaries are having payments for airfare and hotels and their portion of a family trip to be paid for from the special needs trust. Do we have questions on this slide?
We do have a lot of questions, but I think we should keep most of these for the end as they are not related to the slide.
Okay. All right. So a lot of special needs trusts, and it's something that needs to be checked on. Not all of them have this language, but there are times where a trust permits an intentional disqualification. So there can be a disqualification for SSI because particularly in the Bay Area, housing can be very difficult. Affordability of housing is a challenge that faces the Bay Area. So depending on where in the country someone is living, but certainly if they're living in one of the areas in California where this is the case, a beneficiary of a California special needs trust is often facing really exorbitant housing expenses. So one of the things that SSI is supposed to be used for is housing, and you can lose a portion of your SSI if you have been qualified for SSI. So we've talked a bit during this presentation so far about Medi-Cal qualification. You can be receiving Medi-Cal by way of your SSI qualification. So having an onset of disability prior to the age of 18 and having met the SSI requirements, beginning to receive that benefit will also qualify you for Medi-Cal, which we've talked about a little bit. But the SSI qualification, you can be disqualified for SSI or a portion of your SSI if you make expenditures for housing from a special needs trust. There are ways around this. So you can own a house in a special needs trust. A special needs trust can purchase a house. It can receive a house as a distribution from the parent or from whoever is funding the special needs trust. And then it can rent using a small rent payment from the SSI monthly to the beneficiary, so that the beneficiary isn't determined to have a lack of use of their SSI benefit for the purpose of housing. Having a blended rent payment for partial use of SSI towards a rent payment, and then payment from the trustee of the special needs trust for rent can result in the loss of a portion of the SSI every month. So that's an unfortunate tension that we have to work around, and it's the primary driving force behind language in special needs trusts that allows for intentional disqualification, where a trustee is going to make a distribution from a special needs trust that everyone knows will result in a partial loss of SSI benefit because of the fact that it may truly be what is in the best interest of the beneficiary. Do we have questions on this slide?
Yes. So if the beneficiary lives with the trustee and the trustee needs to rent a bigger home, can the trustee charge the extra rent to the special needs trust?
So it gets into murky territory. So all of these scenarios really do need to be looked at with an attorney that's looking at your particular situation, because any generally charging rent is the right answer. But I've had, so in cases where you have a special needs trust and a conservatorship and the court has oversight of the case, I've had courts be extremely diligent in making sure that the portion of household expenses and any rent is no more than the share of cost overall. When you look at, if it's a four-person family, then 1/4. So the allocation of expenses to that one family member that happens to be the beneficiary of the special needs trust, the courts are very, very sensitive to the idea that that person would be charged more than 1/4 of any of the overhead expenses of running that household. I heard an attorney in court recently defending expenditures because there was like a lift being installed in the pool and there was maintenance on the pool. It hadn't been used and was only being used by the special needs beneficiary. And while it's understandable, the judge was not accepting of this at all. So it's something that is, it's definitely kind of a hot button issue if you have any kind of court oversight on a special needs trust. Are there other questions?
Okay. Not regarding this slide.
Okay. Okay, so I've talked about this just a little bit. The general guidelines are that you qualify for public assistance benefits, for government benefits. You have to use those. So you really go through and make use of those benefits first before turning to the special needs trust. In the case of housing, it's a particular issue of any expenditure for housing coming from a special needs trust is going to be a high risk of partial loss in benefit. Food is kind of a different category where you do have to show that you're expending some of your SSI payment towards food every month. That's an important thing to be doing with the SSI benefit monthly. But we generally don't see a disqualification or a loss of any kind of SSI when you pay for food out of a special needs trust in addition to using some of the SSI benefit for it. So generally we want to be using the majority of SSI towards housing and at least a regular monthly amount that is for like the regular grocery bill, for example. But additional expenditures for dining out, ordering food, those types of things that can be food, but also entertainment as well, are not as much of a high risk for triggering a loss of a benefit. Penalties for improper use of funds are a 1/3. Now, this is not as strict of a guideline as it once was. So it used to be more of a reliable metric that we could use where we would say, if you want to intentionally disqualify a beneficiary for their housing, they're not going to lose more than 1/3 of their SSI benefit because you used some of the special needs trust funds to obtain housing for the beneficiary. And we've seen cases where it's threatened more of the benefit than just the 1/3. And we certainly don't want to ever get into a scenario where you compromised the entire qualification for SSI, because then you lose Medi-Cal if you lose your qualification for SSI. Okay, do we have questions on this slide?
One question is, how do you know if trust disqualifications are
the trust document itself will allow for some of the trusts say that you cannot make any disbursements or distributions that would supplant government benefits. So that would be language that would not allow it. And then there's language that would say something more along the lines of the trustee, when a determination is made that there is no way to meet the beneficiary's need using government benefits, can they expend funds for this purpose?
Okay. All right. That's all for this.
Okay. Choosing a trustee. So because of the fact that in every type of special needs trust, the beneficiary themselves cannot be the trustee. They cannot mandate distributions are made. So this is a difficult thing, particularly for a special needs beneficiary that does not have an intellectual disability. It can be very challenging to turn your financial management, your management of your financial affairs over to a trustee. So one of the things that we're going to look at in those types of cases is the family dynamics. So how healthy are the family relationships? How trustworthy are the family members? Do they have the bandwidth, the capacity for staying informed, seeking professional assistance, understanding changes in the law, seeking out guidance and advice as things change over time and as issues might present themselves that weren't initially present? Are they available? Do they have a kind and helpful relationship with the intended beneficiary of this trust? And if the answer is no, then they're not a good fit. And we may want to consider a nonprofit, or we may want to consider a corporate trustee or a private professional trustee. So there's lots of different options for trustees. So for California trustees, if people are interested in looking at the different options that are available for private professional trustees, there is a organization for the licensed fiduciaries in the state of California. It's called PFAC-pro.org is the website. It's the Professional Fiduciary Association of California. So they are licensed. That is their licensing body, and a profile of every licensed fiduciary in the state of California is, you can view all of their profiles on that website. So again, that's pfac-pro.org. So that is definitely something that is a resource worth checking out. Corporate trustees are an option as well, but they can be a little bit expensive, and some of them are better than others at having an actual relationship where they're engaged with the special needs beneficiary, but it can be a little bit more of a distant relationship. So that's something to consider when looking at corporate trustees. So the family dynamics, understanding what options you might have within the family, that's an important conversation to be having with an attorney when drafting a special needs trust. Siblings can be great special needs trustee. It can be something that burns out the relationship. If there's a need to be telling someone no, for benefits planning reasons, I can't do that. I can't distribute this money to you for this reason or that reason. For example, you cannot distribute cash. Cash is always a disqualifying distribution from a special needs trust. So if it's a sibling dynamic or any kind of family relationship dynamic where the inability to give cash to the special needs beneficiary is going to result in a deterioration of the relationship because the beneficiary is so frustrated and so constantly getting angry at the trustee for not being able to just hand them cash when they want it or when they feel they need it. That can be something where we look at other options, even if they cause there to be some expense to the trust, because preservation of that sibling relationship can be a benefit to that child that is a very valuable, huge benefit that is going to promote the disabled beneficiary's well-being in a huge way over the course of many years. And so preserving it is important. Do we have questions on this slide?
Yes, somebody is asking, what is the name of the professional trustees again? Because you have the website, but if you could say the name again.
The Professional Fiduciary Association of California.
Okay. And another question is related to, I think it was the slide before, is would it be better to supplement housing and food expenses beyond the SSI check amount via an ABLE account versus special needs trust? Or is there an advantage of an ABLE account?
Yeah, so the ABLE account is always, now that we have it, it's always a good idea. So I would say we want to fund an ABLE first. And then the ABLE accounts just have limitations. So there's limitations of how much money you can put into them, and there's limitations about how much money they can hold. Whereas special needs trust does not have those limitations. So generally speaking, it's not going to be something that actually does the trick or inheritance, for example, as an entire issue that a parent of a special needs child may be looking to consider or to plan for. It usually isn't going to be something that can be that comprehensive of a solution, but it's usually, now that we have that as a resource, it's something that we do want to consider and most likely to use.
Okay, great. Thank you.
You're welcome. Okay, so let's see. Thorough drafting of a special needs trust. So for any special needs trust, an alternate beneficiary is a very good idea. So having someone who can receive benefits if there's no way to keep someone benefits qualified and to move money outside of the trust. So there are times where the politics change and we are kind of, it feels that in the special needs community, we're a little bit under attack politically. And that anyone who receives anything coming out of a special needs trust for a period of time is going to risk loss of benefits. In those periods of time, we often have alternate beneficiaries that we can move money to, who then can actually often pay for something as a kind of a workaround to, it's not a distribution directly to or for the beneficiary, but it's a distribution to an alternate beneficiary. The idea would be that often it's a sibling that will then apply that money towards a benefit to the beneficiary, but in a as informal a way as possible, so that it won't provide a benefits issue. Residual beneficiaries are the beneficiaries that will receive the balance of the trust, because as I mentioned earlier, we do try to stretch the funds in the trust to cover end of life expenses and the needs at the end of someone's life. So if at all possible, we will try to keep funds on hand through the end of a beneficiary's lifetime, and whatever is remaining, we will distribute at that point to the residual beneficiaries. In the case of a third-party special needs trust, and in every case, a trust that's put into someone's revocable living trust, into the parent's revocable living trust, and then comes into existence later at the time the parent passes away. In every case, that type of trust is going to be allowed to have residual beneficiaries. It's not going to have other creditors related to the child themselves, and it is not going to have Medi-Cal repayment. So it will, the benefit to the family is that at the intended beneficiary's death, the balance will then pass to whoever the alternate recipients are in the broader estate plan, often the other siblings. Do we have any questions on that slide before we move on?
It's a sort of a related question. It's how can 529 college funds be used if a special needs child never goes to college? Can they be rolled into a trust or ABLE account?
You can roll them into an ABLE account.
Okay.
So there's lots of different ways to use the courts if there's not another way to move money that was set up for one use and is not really in the best location. So if you can't through a benefit program that allows you to do it, you can always get a court order that allows you to move money. Generally speaking, you're going to, if you go to seek a court order for the movement of money that was already gifted to a child for their benefit in an account like a 529, you're going to end up with a first party special needs trust and have that Medi-Cal repayment required as part of the court order that allows you to create the trust. So, there's being comprehensive in the planning from the beginning goes a long way, but generally there's always a way to get where you need to go when it comes to special needs trust. So the courts are very accessible, and very engaged in trying to promote benefits qualification and the maintenance of assets for disabled individuals. So they really do. All the courts I even have a case right now where there's a Florida attorney overseeing a trust in Florida, and he's saying that the courts there are also willing to do this as well. So I'm experiencing that it's not just in California, it's actually in other states that we have the courts being very receptive to the types of planning options that we have. If we present a good, viable plan to a judge that's going to allow someone to receive public assistance and to preserve funds they may be inheriting or that they may have otherwise obtained in some way or another, for those extra things that are going to come along as life goes. The judges, every judge that I've come across in every county, many counties throughout the state of California and now in other states as well, as I'm working with other attorneys out of California, they are very engaged and interested in trying to get to what I consider the right result. And I think that most attendees would probably agree. So it's nice to know that we have that. We have the courts really supporting us in doing what is best for a disabled beneficiary, a candidate for special needs trust planning.
Okay, great. Thanks.
You're welcome. All right, so let's see. Acting as a trustee of a special needs trust. So the management responsibility on the trustee is a pretty hefty job to take on. It's a difficult job. Amongst the private professionals, I know that there are those of the private professionals who will not take on special needs trusts. Of those that do take on special needs trusts, they spend a lot of time and they lose a lot of sleep, I think, over things that crop up on their special needs trust cases, because navigating all of the nuances is difficult for anyone, even somebody who makes it their business to navigate. So thinking about putting that responsibility on a family member, again, is something to really consider. Having a family member provide this service is a wonderful cost savings, because you're not going to pay trustee fees, or if you do pay trustee fees, they're going to be much lower in the amount than you would pay a professional or a corporate trustee. But on the other hand, it is a very big responsibility. So you've got all of your general fiduciary requirements. So that's being responsive to the beneficiary, managing the assets, making sure things are income producing. If they're not income producing, making sure that you have a very good reason and that the trust document actually allows you to do it, to manage the asset in the way that you're managing it. For example, a piece of real estate where the beneficiary is living. You wouldn't always be producing income that asset, but be meeting the fiduciary requirements of the trust document. Ensuring that you're making distributions on behalf of the beneficiary, and working hard to maintain qualification for public benefits as you go about making your distributions. And then accounting. So most trusts require accountings. So anything that is put in place by court order, the court will usually maintain supervision of that going forward. So if you have to ask for a court to give you the authority to create a trust, you're often then going to be going back to that same court at the first year and then biannually after that. So every other year after that, until the special needs beneficiary passes away, to provide the court with an accounting, and the court goes through that with a fine-tooth comb. You have to answer for any expenditures that the court doesn't like. So it's a very time-consuming process that requires a lot of diligence, very good record keeping, and compliance with all of the various rules for special needs trusts. Often, if it's not court supervised, it still is going to require accountings, and beneficiaries who are not are disabled but not intellectually disabled will have the ability to go through their own accountings and to see if they have any questions or have any concerns about expenditures. Often it would be someone else who's entitled to receive the accountings if the beneficiary is not going to be able to do that type of review and kind of oversight of the trustee's diligence and how to just kind of check and make sure that they're doing a good job. We would want to have someone else have the ability to check on that and make sure that we have like a system of checks and balances, that the trustee is managing the money in a way that really does benefit the beneficiary and maintains benefits qualifications. If there's a disqualification, that it truly is in the best interest of the beneficiary and that the assets are managed appropriately. There's not mismanagement or investing in a friend's vacation residence as a supposed real estate investment or something like that. Are there questions on this slide?
Yes, I have a question here. Is monies put into a CalAble account protected from Medi-Cal recouping cost?
I think that the ABLE provisions are something that would be best covered in a different presentation, because it's a whole
Another
topic into itself, and we're actually
running out of time.
Yeah, I think we need to not get into ABLE. It's important to note that it's an important component of planning now that we have the ABLE program up and running. It should be something that is considered as part of a comprehensive plan, but it really is truly deserving of its own whole hour-and-a-half presentation.
Okay. Then let's keep going.
Okay.
Yeah.
So this special needs trust can be the recipient of the income received from a tax deferred account like an IRA. It can, the trustee can be responsible for taking the required minimum distributions, or the institution can direct the distributions to the special needs trust. There is a way to avoid the distributions from disqualifying, but if there isn't careful planning done, they will otherwise disqualify. We have a little bit more flexibility at this point because of some added program language that allows us to do assignments of the income from a retirement account to a special needs trust now. But in the past, when we didn't have quite so many options available to us, we were often considering, and I can imagine that there may still be cases where I would consider looking at skewing the distribution where certain assets of certain types may be received by the special needs trust, and more of a different type of asset, like for instance, in the past, it was often a retirement account, might be skewed towards a different family member, a different sibling, often would be the case. So when we talk about the flow of funds, do we have a question?
Yeah, so given recent passage of Secure Act, would it ever make sense to have a special needs trust to be the beneficiary of an IRA? Does the answer differ? Is it a different answer dependent on whether it is a traditional versus a Roth IRA?
Generally speaking, a Roth isn't going to pose any problems. The traditional IRA, there are different rules for the Secure Act. Actually preserved all of the things that existed pre-Secure Act for disabled individuals. And so the criteria for whether you meet the stretch requirements or the ability to roll that inherited IRA out over a lifetime are very similar to, if you've met the standard for receiving SSI, generally you're going to meet that same standard. If you've met the standard for SSDI, alternately, you are going to meet that standard. So if you've met Social Security's disability standard on either front, either SSI or SSDI, then you will be allowed to still stretch your IRA even post Secure Act passage. That was one really nice thing that was built into the Secure Act. So that's one thing. There are cases where I'm dealing with one now where you can have an RMD even stretched out over someone's lifetime if the IRA is very sizable. That will require larger distributions than will allow for benefits to be maintained. So that's where looking at an assignment of that income as it's distributed from the IRA is something that will be considered. If the parent or whoever is leaving the retirement account at their death names special needs trust as the recipient of the retirement account, that solves that problem. Roth IRAs are post-tax, so that's not going to be something that is going to pose a planning problem. So yes, it's different. it's different in a good way where you don't really have to worry about the so much of the planning kind of matrix around it.
Okay. Okay, so another question is, can the life insurance money go to the special needs trust after parents' death?
Yeah, so some special needs trusts are created to operate as a life insurance trust, an irrevocable life insurance trust. So there's a long history of special needs trusts being created as a life insurance recipient, as a device specifically for life insurance. So there's even reasons why in some cases you may gift the premiums to the special needs trust and have the special needs trust acquire the policy itself. And then the policy is on the parent and the parent passes and the policy pays out to the trust, keeping that entire device outside of the parent's estate. So the parents don't have estate tax to be paid at their death on that, the payout from the life insurance policy. There's lots of different options for planning with life insurance and special needs trusts. So yes, absolutely. And there's a very long history for that and different ways that you can go about doing it. Certainly the most, basic is to have a special needs trust and to name it as a beneficiary of your life insurance policy. Some life insurance companies and retirement companies, the financial institutions that may be managing those policies or those contracts for an annuity or the accounts for retirement accounts will not allow you to name a special needs trust as a beneficiary if it's not an existing entity. So in that case, you might need an actual entity to be established so that it has its own tax identification number, and then it can be listed as a proper beneficiary to be the recipient of those benefits at the death of the parent or whoever is leaving that money.
Okay. All right. Thank you.
You're welcome.
Okay, and we're running out of time here. So we're thinking that we're going to just kind of wrap up special needs trust so we can at least jump into conservatorship for a little bit for everyone.
Okay.
Do you want to just take another minute to wrap up?
Sure.
Something?
So generally speaking, we don't want any assets to be received by the disabled individual before they are funded to the trust. If we can avoid it, we want assets to transfer directly to the special needs trust so that there's not a disqualifying event for the special needs beneficiary. And that concludes our special needs trust component of this presentation.
Wonderful. Thank you so much. And we really appreciate you talking us through that and answering all of our questions.
You're very welcome.